Kuwait's economic landscape is undergoing a regulatory contraction, targeting one of its most common business practices. For years, foreign investors operating in the region have utilized a workaround known as license renting or proxy ownership. As this structure shows, the arrangement relies on a division of roles. A foreign operator secretly funds and runs the business, while a local citizen holds the front-facing commercial license and legal title. The primary motivation behind this setup is to bypass the standard foreign ownership quotas established by local corporate law. Many operators treated this gray market maneuver as a standard reality of doing business. It was an open secret. Relying on that historical assumption now places an operator in direct conflict with the state. Under this new decree, this foundational business practice is no longer an administrative oversight. It is a criminal offense. Kuwait's newly published Decree Law No. 78 of 2026, regarding combating commercial concealment, criminalizes the entire proxy ownership model. This sudden legal shift directly targets the thousands of existing corporate structures built entirely on informal, handshake sponsorship agreements. Published in the Official Gazette on August 9, 2026, the law immediately triggered a strict 6-month grace period. When that timeline hits February 2027, the grace period expires and full criminal enforcement takes effect. To meet this deadline, companies must proactively restructure their existing shadow operations before government regulators initiate criminal proceedings. Article 1 of the new decree provides a precise statutory definition of commercial concealment. The law targets two entities: the concealed foreign operator and the concealing local license holder. The connection defines the illegal mechanism, enabling a person to practice a prohibited economic activity. Bypassing foreign ownership quotas is now categorized as a criminal act of concealment. Article 2 adds an absolute prohibition on allowing anyone else to use your commercial name, license, or registry. License renting is now an explicit, standalone statutory offense. It creates joint liability, putting the local sponsor and the foreign operator directly on the hook. A financial dispute over proxy ownership is no longer handled as a civil contract issue. It is prosecuted as a coordinated criminal enterprise. Article 3 establishes the penalty matrix, setting a baseline prison sentence of 1 to 3 years for violators. This is paired with statutory financial penalties, ranging from a minimum of 10,000 up to a maximum of 100,000 Kuwaiti dinars. As this scale illustrates, there is an alternative penalty clause. The fine can instead equal the total value of the illicit profits generated by the business, whichever amount is greater. These fines are not static. The law dictates that they multiply for every individual offender and every distinct illegal activity discovered. Article 6 shifts the consequences from financial penalties to the termination of the business itself. In the event of a conviction, the court mandates permanent closure, confiscation of all funds, cancellation of the license, and deportation of the operator. A conviction triggers the simultaneous seizure of assets, the loss of legal status, and the physical removal of the operator. The law is designed to dismantle the commercial entity entirely. Executives often rely on the corporate shield, assuming their status protects them from structural violations of the company's owners. Decree Law 78 removes that protection. Article 5 introduces specific liability for the actual manager of the violating entity. As this org chart shows, liability bypasses the corporate entity layer. If the manager knew of the concealment, or if the violation occurred because they breached their administrative duties, the state targets them directly. Operating a proxy structure while serving as the active manager now guarantees personal criminal liability equal to that of the owners. The government's primary enforcement mechanism is asymmetric. They are weaponizing the company's own workforce and external network to audit the market. Article 9 establishes a state-sponsored whistleblower bounty. This diagram outlines the flow of funds. The state intercepts the illicit wealth through fines and redirects a percentage of that cash directly to an anonymous informant. Up to 10% of the collected fines are paid as rewards to non-accomplice informers who provide evidence that leads to a final conviction. This shifts the threat matrix. Employees, business partners, and competitors are now financially incentivized, state-backed auditors. The internal risk of exposure now outpaces the threat of external regulatory audits. Keeping a proxy structure hidden from your own staff is no longer a sustainable strategy. If a proxy structure is discovered before a final judgment is issued, Article 8 offers a punitive off-ramp known as reconciliation. This decision tree maps two outcomes of discovery: progress to trial for maximum penalties, or the pre-trial reconciliation path. That path comes with a high cost, paying a minimum of 50,000 dinars. Furthermore, the mandatory prerequisite is the immediate correction of the entity's legal status. This option is entirely void for repeat offenders. Reconciliation is a punitive off-ramp that forces total legal compliance while extracting a severe financial penalty in the process. To avoid prosecution, businesses must execute immediate operational steps. Informal proxy agreements must be terminated, and official registries must be aligned to reflect actual management and ownership. There are legitimate pathways for foreign investment and ownership in Kuwait to replace these informal models. Law number 116 of 2013 regarding direct investment provides a legal framework that allows up to 100% foreign ownership in specific, approved economic sectors. For those outside those sectors, executing a standard corporate restructuring and reallocation of shares under Kuwait's companies law serves as a reliable compliance pathway. These complex structural changes require legal auditing and state approvals, and the 6-month deadline runs out in February 2027. By February of 2027, every commercial structure in Kuwait must match its registered ownership to its actual management. The informal proxy system has been replaced by a regime of mandatory statutory compliance.